सिमेट्रिक के ऊपर, तो उसमें 3D का ऑब्जेक्शन आया, जो कि हाई कोर्ट, फर्दर अपीलेट, IPAB एंड फर्दर सुप्रीम कोर्ट सबने रिजेक्ट किया उसको, ड्यू टू इनहांस एफिकेसी जो है नहीं है उसमें थेरेपेटिक एफिकेसी के बारे में लेकर के। बाकी बहुत कुछ है।
Yes. So in the Novartis case, they have why this is the landmark judgment, because one reason is that Novartis versus Union of India will be there, right? So directly the patent office will be involved over here. So that is the one of the reason. Then second, this case goes to the Supreme Court, till the Supreme Court. So some of the in the another cases also the Union of India Patent Office will be involved, but all the cases are not goes to the Supreme Court. Or if the cases are goes to the Supreme Court also, but this is related to the landmark, because on the section 3D, if anyone wants to take any of the judgment or any of the decision for the particular upcoming any products of the pharmaceutical products, so that they are referring this case, because for the each and every products of the pharmaceutical inventions, pharmaceutical field, they are more or less they are comes under the 3D section only, because they are changing some of the ingredients in that, they are changing some of the structure of the pharmaceutical component or the API, we can say the drug. So based on that, based on this judgment, the people were taking the further decisions for the upcoming patents. So that's why this becomes a landmark judgment, and this will be as since this will be happened on the 2012, right? So now it's the 2022. So after 10 years also, this case having a equal impact, because the 3D section will be there, the pharmaceutical invention will be there. So if we are combining the 3D with the pharmaceutical invention, for that we have to check this case whether it is related to this case or not, because in this case they have given the therapeutic efficacy related definition. So that is very important. If the people will saying that I'm come up with a new salt, I'm come up with a new any polymer, any polymorph, I'm come up with any new form of that particular available product, and it will give the efficacy or increase the efficacy. So enhancement of the efficacy, or specifically the therapeutic efficacy, how it will be defined. So that will be defined into this case, and that's why this case will be used for the further evolution of the further products. Clear?
Yes.
So what we are referring this Wikipedia. Other than that also I have some other documents also, but we'll refer this one. So in this case, what we have to, they will mostly ask in the 4 or 5 marks question. So 5 or 10 marks question. So in that also you have to, at least you have to write down the 4 to 5 pages, right? Over that. So based on that they will give. But now whole the judgment you cannot write over there, because there is the lack of time also, and there is no need of the each and every line will needed to write in this case, if this case will be asked. So first the flow you have to write the what is the patent. First you have to give the patent details, what exactly the patent will be, when it will be filed, that patent is related to what, and this is related to the another already parent patent is already there, right? So some basic details about the parent patent. So this is all about the patent details about the patents of the child patent as well as the parent patent, or the imetimide mesylate and their new salt or the new polymorph. Then give the how this how they have given the arguments in the which clauses or the in the which grounds. First the examiner has given their for example for the novelty, or for section 3D for the inventive step, on the which ground they have objected in the patent office. Then how the Novartis has responded to them. After that, that also the thing that patent will be rejected due to the section 3D objection. Then at the time the IPAB will be there. So the Novartis will be goes to the IPAB that the patent office rejected my patent, but I am come up with a very good invention which giving the high therapeutic efficacy. So that detail you have to give. Then they will goes to the High Court and then Supreme Court. So generally in this case they have filed this special leave petition. So what do I mean by the special leave petition? So if any person or any company will file the special leave petition. That is the one phenomena, or we can say that is the one type by which we can directly file the case into the Supreme Court without going to the High Court. So from Novartis, from the IPAB, generally it goes to the High Court and then it goes to the Supreme Court. But in this case, they are directly goes to the Supreme Court, and that phenomena is known as the special leave petition. They have to apply for the special leave petition, and they will go to the directly to the Supreme Court. In that also they have argued by the Patent Office or the Union of India, and by the Novartis also, and in the last Novartis will be close this case. So in that also you have to write down the basic about the Patent Office, then hold the patent applications, then hold the patent in the whole the procedure of the this case. Then in the last the decision, and before that you have to write down the therapeutic efficacy related definition, because that is the main thing which people are still referring from this case. So what do you mean by the therapeutic efficacy by the way of this Novartis case? That also we have to write down in the one paragraph over. So they, based on that, they will give the some of the marks that okay, this is the basic definition of the section 3D, that is basic definition of the therapeutic efficacy. So in this, for this also I will try to give that write up how you can write about this case, because this is the very long case. So each and every things we cannot write in the paper, right? So I will try to give those things how you can write down this case if this case will be asked. And if they will not ask in the exam, then also they will sometimes, if you will say that if you are from the pharma or the chemical background, definitely in the viva they will ask about the Novartis case. Generally, out of the 50 candidates, if the 50 candidates are from the pharma background, so out of that to the 40 candidates they will ask this Novartis versus Union of India case. So the Novartis in the Union of India and others is the landmark decision by the two-judge bench of the Indian Supreme Court on the issue whether the Novartis could patent the Gleevec in the India, and was the culmination of 7 years long litigation fought by the Novartis. So in that one you have to remember is that this is the case is between whom? Novartis and the Union of India. The last judgment is given by whom? Supreme Court, Indian Supreme Court. Then for which product or for which patent, so that brand name is the Gleevec. Gleevec in bracket also you can write down that the imitinib mesylate. So for that they have applied, and the case will be happened for 7 long years. Litigation will be there. And the Supreme Court upheld the Patent Office rejections of the patent application. Means the Supreme Court also in line in the decision with the Patent Office decision. So first paragraph you can take from here, or I can also give some modified things of this. Then the patent application at the center of the case was filed. They have given the details over here. So you can also give some heading when you are writing into the paper, that this is the basic you can write down as a first paragraph. Then in the second paragraph you can write down that the details about the patent application or the patent applications for the patent application filed for the imitinib mesylate. So for that is the parent patent will be included, the child patent will be also included in that. So give the title over there, and then you can give the details of the parent patent in one paragraph, and in the second paragraph you will give the patent details about the child patent, or this for the patent for which this whole case will be happened. So the patent application at the center of the case was filed by the Novartis in the India in the 1998, after India had agreed to enter in the World Trade Organization and to abide by the worldwide intellectual property standards under the TRIPS. So in general, WTO and the TRIPS agreement, once the India will enter into this WTO and TRIPS, at the time in the 1998, this case will be filed. A part of this agreement, India made changes to its patent law, the biggest of which was the prior to these changes, and patents on the product were not allowed, while the afterwards they are albeit with the restrictions. These changes come into the effect in the 2005. So as I have told that the one of the provision will be there in the patent law, which is now removed, that is the exclusive marketing rights, or we can say it's the black box or the mail blocks they are telling. So in that, what they are doing in the before the 2005, if anyone wants to file the product patent, product means as such drug molecule related patent, so that can be filed under the black box. And after 2005, that product patent will be taken on the table. On further process will be started for that. Right. So that is black. This is particularly at the time era of the black box application, or the this exclusive marketing rights application for the product patent related things. So in that, the manage the transition, India also passed certain amendments in the patent law of the 2005. So now, once the patent Indian patent office or the India has signed with the WTO and the TRIPS agreement, after that they are started allowing the product patents. Before that, there is no scope for the product patent. Now they have started allowing the product patents. So for that, they have kept the mail blocks or the black box applications, and with that also they have given some of the amendments into the 2005 patent law. So based on that, the patent application claimed in the final form of the Gleevec, that is the beta crystalline form of the imitin mesylate, in the 1993. During the time, India did not allow the patents on the product, right? So from in this time, in the 1993, there is no product patent is allowed. At the time, Novartis had patented the imitin. When the products, generally the product patent is not allowed. At that time, Novartis have a patent for the imitin with the salts of the workplace specified. They have not clearly specified about the salt. This is the mesylate salt. For that, they have filed another patent. But at the time, the product patent of the imitin, which will be already granted, for that they have there is no specific salt. They have given the list of the salt, but there is no specific salt over there. In the many countries, but could not patent it in the India. This because at the time the product patent is not allowed in the India. Now the key differences between the two patent applications were that the 1998 patent application specified in the contract that is a specific salt, imitin mesylate, while in the 1993 the patent application do not claim any specific salt, nor did it any mention of the mesylates. And in the 1998 patent application specified the solid form of the Gleevec. The way of the individual molecule are packed together into the solid when the drug itself is manufactured. This is separated from the process by which the drug itself formulated into the pills and the capsules. So while in the 1993 patent application did not. So first one, they have given details about the in the 1990 patent, means the later on patent, they have given the details about the salt. In the second, they have given the details about the formulation, like in the pills or the capsules of that particular mesylate salt. Well, in the 1993, they have not talked about any specific salt. They have not talked about the formulation. The solid form of the imitin mesylate is the Gleevec, that is the brand name, is the beta crystalline. So, as provided under the TRIPS agreement, Novartis applied for the exclusive marketing right for the Gleevec from the Indian Patent Office. So, at the time, product patent will be not there, or you can ask for the exclusive marketing right. So, give me the rights. The Novartis will ask to the Patent Office that give me the rights for the exclusive marketing of my particular Gleevec product from the patent office, and the AMR were granted also in the 2003. Now Novartis made a use of the AMR to obtain the order against some of the generic manufacturer who had already launched the Gleevec in India. Now Novartis set the price of the Gleevec USD 2,666 per patient per month. So this is a very high price for per patient per month, and the generic companies were selling these things in the $177 only. So there is a very high gap of the price, right, to the 266 per patient per month. So the general is the 177 to 266. So almost the 1/10 of this they have sell the product. So Novartis also initiated a program to assist a patient who could not afford its version of the drug concurrent with the its product launch. Now, when the examination of the Novartis patent again application becomes 2005, so they have applied in 1998. After that, The examination will be start on the 2005 because what as I have told that the black box application or the box application. So if before 2005 anyone has filed about the product patent, then that application will remain as it is till the 2005. So after that, the examination will be started in the 2005. Then it come under the immediate attack of the opposition initiated by the generic companies that were already selling the Gleevec in India and by the advocacy group. So as on the previously product patent will be not there, right? So if the product patent will be not there, then generic companies are already started marketing of this and manufacturing of this product Gleevec. Once this patent will be filed for this, then they have filed the opposition. Application was rejected by the patent office and the appellate board means the RTP board also. The key basis for the rejection was the part of the Indian patent law that created in the amendment in 2005 describing the patentability of the new use of the known drug and the modification of the known drug. So this section 3D will be incorporated at the time of the amendment into the 2005. So section 3D will be there of the Patent Act specify that such inventions are not patentable such inventions are patentable only if they differ significantly in the property with respect to the efficacy. That is also particular respect to the therapeutic efficacy. At one point, Novartis went to the court to try to invalidate this section 3D. It argued that the provision was unconstitutionally vague and that is violated the TRIPS. Novartis lost the case and did not appeal. Novartis did appeal the rejection by the patent office to the Indian Supreme Court and they took the case. The Supreme Court case here also you can write down about the section 3D, the things which patent in the patent law they have mentioned each and every line you can write over here. That examiner also come to know that you have idea about the section 3D. Then in the efficacy point you can do the underline. So the examiner also come to know that okay for the section 3D this person having a knowledge and this is particularly related to the efficacy. So that also this person having enough knowledge about that. The Supreme Court case hinged on the interpretation of the Section 3D. The Supreme Court decided that the substance that Novartis sought to patent was indeed a modification of a known drug. The raw imetinib will be imetinib, which was publicly disclosed in the 1993 patent application and in the scientific articles that Novartis did not present the evidence of the difference in the therapeutic efficacy between the final form of the Gleevec and the raw form of the imetinib, means imetinib mesylate and the imetinib, and therefore the patent application was properly rejected by the patent office and the lower courts. That they will check by the Supreme Court. Although the court ruled narrowly and took care to note that the subject application was filed during the time of the transition of the patent law, and the decision generated widespread global news coverage and reignited debates on the balancing the public good with the monopolistic pricing and the innovation with the affordability. Had Novartis won and got it the patent issued, it could not have prevented generic companies in India from continuing to sell the generic Gleevec, but it could have obligate them to pay the reasonable royalties under the grandfather clause includes the Indian patent law. There is no patent has been granted. Here is something wrong. The paper which I have said with you, right? This one.
Yes, madam.
This paper I have shared with you. As a PDF.
Okay.
So that is related to the Novartis case. So you can refer this. Although they have given the whole the events in this table format with the year wise. So in that they are telling. So the Indian Supreme Court on the 1st April 2013 delivered a landmark judgment rejecting the Novartis 1998 Indian patent application for beta crystalline form of the imatinib mesylate, a drug used to treat the chronic myeloid leukemia, the type of the blood cancer, marketed under the name of the Gleevec. This is also ended the Novartis 8 years battle with the various Indian legal forum to get its drug patented. Then the Supreme Court for the first time has interpreted the Section 3D. So first time the Supreme Court has interpreted this Section 3D, and that's why this becomes a landmark judgment of the Indian Patent Act, which attempted to curtail evergreening of the patents, because already the patent for the inetimate will be already there, right? So if you are if the patent office will be grant the patent for the its upcoming source, so the evergreening will be there. So to prevent these things, so they were coming, the patent office, the section 3D will be added to stop the evergreening of the product. The Supreme Court in its 112 pages, means in the 112 pages, judgment will be there for this Novartis related cases, and that will be taken for the Justice Tekchand Committee reports, and the Justice Ayanagar reports will be there. Now they have given the whole the events with the timelines on the July 17th, 1998. Novartis has the file. So in the July 1998, Novartis has filed the Indian patent application for beta crystalline form of the imatinib mesylate. At that time, the act allowed acceptance of the product patent, because at that time they have allowing the application for the product patent in the mailbox, and that will be examined after the post 2005. They will examine as per this TRIPS agreement and all. So in the 1998 to 2005, application remains as it is into the mailbox. Then the 2002 to 2003. In the meantime, Novartis says, now in the 1998, Novartis has applied for the patent. Then that application will be remains as it is. Now after that, in the 2002 to 2003, that 1 year period, the Novartis has also applied for the exclusive marketing right from the patent office with relation to the product under then existing section 24A of the act, which is now omitted, which also was in line with the TRIPS. Then in the January 1st, 2005, India introduced the product patent regime and simultaneously amended the Section 3D, and Section 3D disallowed the patenting of the new variant of the already known substance unless such new form has significantly efficacy over the older version. So only the any newer forms, either in the salt, either or it's the any new polymer, they are not allowed. But exception will be there if you can prove that your newer form will be a higher efficacy. Then and then only you can get a patent for that newer form. This was introduced with the view of the prevent evergreening and the granting of the fabulous patents. Then in the 2005, the Novartis patent application, before it was taken to the examination attest, the 5 pre-grant opposition will be filed for this patent application by the NATCO, CIPLA, Ranbaxy, Vitro, and one is the Cancer Patient Aid Association. These all have applied for the pre-grant opposition, because the price of this product is very much higher, so that is not affordable for the any new normal or the normal human being for to purchase this drug. So for that, the total 5 companies or one of the association has filed the pre-grant opposition for this patent application. Now in the January 25, 2006, Assistant Controller of the Patent held a pre-grant opposition and rejected the patent Novartis patent application. So in the pre-grant opposition stage only, the application will be rejected on the grounds that the application is lack of the novelty. There is not only the one ground of the Section 3D, but one is the lack of the novelty. It was the obvious, and third one is that is the comes under into the Section 3D. Control held that the product was the new version of the older molecule that Novartis is first filed in the 1993. So first parent patent will filed into the 1993, and the increment in the efficacy is not sustainable enough to receive the grant of this patent, because they are the Novartis failed to give the data of that increment or the increase in the enhancement of the efficacy. So in the May 2006, since the appellate authority of the IPAB under the Act was not established at the time, so Novartis had filed the writ petition before the Madras High Court against the Union of India. The Controller General means the CGPTN. The Controller General of Patent and Design means the controller. Then the opponent against them, Novartis is filed. So in the pre-grant opposition, application will be rejected. After that, there is no IPAB at that time. So they have filed, first they have filed in the Madras High Court against the Union of India, controller, and all the opponents which they have filed for the pre-grant oppositions. Novartis contended that the controller erred the interpreting the means the argument by the Novartis is that the interpretation of the section 3D that is done by the controller, that is not a proper thing. Means they have not properly interpreted those things for the enhancement of efficacy under the section 3D with regards to the product of the new product. They have applied for that, and what they have told, the controller disregards the in-house laboratory tests performed by the Novartis scientists on the rates, and that show that the 30% increase in the bioavailability between the imetamine and the imetamine mesylate was adequate to meet up the enhancement efficacy, which is the benchmark for the section 3D. So, in the 2006, once the patent will be rejected, the case will be goes to the High Court, Madras High Court, and in that the arguments from the Novartis side is that they have performed the efficacy related study, bioavailability related study on the rates, and they will get the 30% more efficacy as compared to the original drug. That is the argument by the Novartis. Now in the 2007, the central government issued the notification under this section 117G of the Act, hereby all the appeals from the order of the controller pending before the High Court were transferred to the IPAB set up in the Madras. So at that time, IPAB will be set up in the year of 2007. So the whole the proceeding which are ongoing into the Madras High Court, that will be transferred to the IPAB that will be formed at the Madras. Therefore, the Madras High Court transferred the appeals from the controller's order rejecting the patent to the IPAB. Then, however, the Madras High Court reserved the right to pronounce its judgment on the issue of the constitutional validity of Section 3D for the 3D. Then, in the 2007, in the August month, the Madras High Court held the Section 3D does not violate the Article 14, right to the equality of the Constitution of India, and the order was not appealable further by the Novartis. So in that they have given that now the order which are given by the IPAB or the Madras High Court, that cannot be appealable under this Article 14 of the Constitutional India. Then in the 2009, IPAB reversed the decision of the Assistant Controller on the issue of the anticipation and the obviousness. Means total 3 grounds are there for the pre-grant opposition. One is the anticipation, means the novelty, lack of the novelty. Second is the lack of the inventive step or the obviousness will be there. And third one is the Section 3D. So in the IPAB, that both the newness and the non-obviousness, both the things will be reversed. Means for that controller given the positive sign to the Novartis that for the anticipation or the novelty will be there. For the imetamine mesylate, because it's a new salt, and the inventive step will be also there because to form a new salt which giving you 30% more therapeutic efficacy, that is fair enough to justify the inventive step. However, the IPAB held that the subject matter of the patent application was barred from the patentability under Section 3D. So for Section 3D, IPAB has given the negative impact that for the Section 3D, the Novartis will be fall into the Section 3D. But for the novelty perspective and for the inventive step perspective, Novartis will be outside of that. And therefore, they rejected the patent. So now IPAB has also rejected the patent based on the Section 3D. However, it allowed the process patent for the product. So at the time, the process patent, which is another patent which are filed by the Novartis, that is allowed by the IPAB. Then in the the things which we have confused at the this Wikipedia related documents. So in that the process patent they have granted, but for the product patent they have still rejected based on the Section 3. So after that, in the 2009, against the order of the IPAB, Novartis filed a special leave petition, as I have told, under the Article 136 of the Indian Constitution in the Indian Supreme Court, because as I have told that for the Madras High Court under Article 14, they have told that now the things or the appeal by the that the decision by the IPAB or the decision by the Madras High Court, that cannot be appealable. So after IPAB, generally the High Court will be there, but as this already Madras High Court is involved in that and it's told that this is not appealable, that's why the Novartis directly goes to the Supreme Court, and for that any person who directly wants to go to the Supreme Court by bypassing the High Court, they have to file the special review petition. So they have filed it, and after that, in the 2013, the order will be come out, which is told that the product patent for this imetinib mesylate, that is not patentable under the Section 3D, and the Novartis failed to prove that this imetinib mesylate having the higher efficacy as compared to the raw imetinib. So this table is also very good. If you cannot remember the date and month, then it's okay. But in the year wise also, you can write down the events. So they will give the day 1 to last days whole the details in this your that case, and that will give you the very good marks. With that also, you can write down the some of the points which give the more details about the therapeutic efficacy, more details about the patent application related details. The Supreme Court
Yes.
had made one exceptions and admitted this special leave petition, sidestepping the jurisdiction of the Madras High Court in the view of the importance of the case and the number of the seminal issues that were involved in this case. Because, as I told you, this is the landmark case because the interpretation of the 3D is very important in this case, and based on that only the further cases will be interpreted. So. This case is important, and based on that, special leave petition will be accepted by the Supreme Court. The Supreme Court noted that this was on exceptions, and any attempt directly challenging the IPAB order before the Supreme Court, sidestepping the High Court, was strongly discouraged. Right. So, based on that, they have given first the invention versus the patentability. They have checked the things they have given into this. The write-up or this case. So what they have given in the first, they have checked the invention versus the patentability. So on subject matter, in order to get the patent under the act, has to pass the test of the invention and the patentability, both being distinct the concepts. So invention and the patentability both are the different. If the invention is not patentable, that doesn't mean that the invention is not an invention. Because anything which are come new and it will give the benefit to the society and the country or the people, then it is the invention. Or if something is new, then it is an invention. But it doesn't mean that the invention is all the inventions are the patentable. And if the invention is not patentable, then doesn't mean that the invention is not an invention. Hear this?
Yes, madam.
Yes. So for that first, those things we have to check whether it's the invention is there or not. If the invention is there, then it is patentable or not. So, in order to for the subject matter to pass the test of the invention, it must satisfy the following conditions is laid down by the section 21J and the 21J. So, one is the new name, means the novelty. Second one is the industrial applicability, and third one is the inventive step. And inventive step also, we know that there is a three concepts are there. One is the advancement into the already existing work. Second is the economical significance, and third one is the both. And that those things is not obvious for the person skilled in art. So this is the definition of the inventive step. That also you can write down if you have time. In that, once the product or the process is passed, the taste of the invention, it also has to pass the test of the patentability. So the subject matter passes the test of the patentability if it has not been specifically excluded from the patentability under this act. Means the section 3 and 4 are there. If the invention will be there, so invention has to pass the three criteria: novelty, inventiveness step, and industry applicability. With that also, if that invention has to file for the patent or to make it that invention a patentable, you also have to check the section 3 and 4 for whether it is the patentable or not. So for checking the invention is there or not, three criteria. After that, further you have to check for the patentability. For that, you have to check for the section 3 and D. Now the invention as claimed in the patent application was the beta crystalline form of the imetamine mesylate. This was a derivative of the free base form called the imetamine. Means it is the derivative or the beta crystalline form or the salt of the imetamine mesylate of the imetamine. Disclosed widely in the example 12 of the patent application filed by the Novartis in the 1993. So that if you cannot remember, you cannot write. You can just write down that in the parent patent or in the product patent, which is filed in the 1993. In that product, this is the derivatives of the free base called imetinib that is disclosed. Means the specifically mesylate will be not there, but in the example 21, they have given that the sum of the derivatives of the imetinib in the parent patent. Now, according to the Novartis, the invention as claimed in the patent application involved the two inventions. The first invention involved the selecting the example 21 out of the 37 examples given into this patent, that particular patent which is filed in the US, the parent patent, and then choosing the methanic sulfonic acid to produce the methanic sulfonic acid addition with the addition salt of the free base of the immediate called as the immediate mesylate. So in that parent patent, they have given total 37 examples. Out of that, you have to select the example 21. That is also a tedious task, or it is also take a more experimentation. So from that, you have to select the example 21. Then in all that also you have to choose the methanonic sulfonic acid, and if when you are reacting this methane sulfonic acid with immediately, it gives the immediate mesylate. So the second invention involved the making of the imetamine mesylate. So first is the product, means that the newer product or the beta crystalline form that they have come up. For that they have applied one invention is there. Second one is the process for making of them. So that is the second invention. Now according to the opponents, this patent, the parent patent addition to the imetamine was disclosed in the imetamine mesylate. So the addition of the methane sulfonic acid that is known into the example 21, that is known into the parent patent. And there was only the invention now that is known means that is not a patentable. Now the only the second invention, that is the process for making that methane mesylate salt, that is the unique one because that is not disclosed into the parent patent. So now that is the another invention and that is patentable. Now the imetamine and imetamine mesylate, between these two products, they have given the comparison. So in order to verify the claim of the Novartis that its application involved two invention, it was essentially for the Supreme Court also to determine whether that parent patent addition to the imetamine, this parent patent addition to the imetamine were disclosed as the imetamine mesylate. If the answer was the affirmative, then the Novartis claim of the two invention was the incorrect. But if this parent patent did disclose this imetamine mesylate, the first invention, imetamine mesylate, would not be qualified under the section J1, 21J and 21J, and as it will not be technical advance over the existing knowledge. So first, Supreme Court had or the opponent has what they have to check whether this immediate mesylate as such is, or by the any somehow about any other way, if it is known into the parent patent or not, or it is already known by some way, either it's a directly or the indirect way. So then it will come out from the criteria of the section 21J and J, means there is no patentable, there is not a novel and the inventive step will be there. Now the Supreme Court referred the following disclosures which are given into the parent patent and the development surrounding this patent, because as such, if the things will be not there, but if the person skilled in art will taking some teaching out of that, and based on that, if easily they can produce this imetamine mesylate, then that also not fulfilling the obviousness criteria. So in that the may form acid addition salts, they have given the line which is already given into the parent patent. So what the line they have given, may form acid addition salts, for example, with the inorganic acids such as hydrochloric acid, sulfuric acid, or the phosphoric acid, or with suitable organic carboxylic or the sulfonic acid. They have given the different types of the acid, and if the with that, if the imetamine will react, then it will give this some additional salt. Now, second line, what they have given, any reference to the free compounds could be understood as including the corresponding salts where the appropriate and the expedited. So the invention relates also to the method of treating of warm-blooded animals suffering from this tumoral disease, which comprising of the administering the warm-blooded animal requiring such treatment and effective and tumor inhibiting amount of the compound, the formula 1 or it's a pharmaceutical acceptable salt. So generally, when you are checking the pharmaceutical patents, generally they are what their language will be there, any particular drug or pharmaceutically acceptable salt thereof, right? So they in that they have covering all the types of the salt. So here also they have used the same language. So the mesylate is also the one type of the salt. As such, they have not mentioned, but they have mentioned two things. One is acid addition salts will be they have disclosed which type of acid you will add, and based on that you will get the salt. Let's for example, if you are adding the hydrochloric acid, then you will get the imetimid chloride as a salt. So they have given little bit idea about that. If you are adding any acid, then you will get the salt. Second, what they have also write down in the claim that the imetimid and the pharmaceutically acceptable salt thereof. So they have given the salt idea for the salt over there. Then based on that, once on the April 9, 1998, Novartis had filed a new drug application, means NDA they have filed to the Food and Drug Administration that is based on the US. So US FDA they have filed, that is the regulatory authority which are giving the approval for marketing and manufacturing the any pharmaceutical products. So in the US FDA, so Novartis in the 1998, Novartis has filed a new drug application for the Gleevec, means the imetimid mesylate, which it had furnished the information that the active ingredient of the drug was imetimid mesylate, and the same was covered by the parent patent. This thing they have given into when they have filed the FDA related all the regulatory documents. In that they have given that what they have given that the information about the active ingredient of drug was imetimid mesylate, and that same was covered into the parent patent. These details they have given into the FDA regulatory documents. Now FDA approved the Gleevec imetimid mesylate in the 2001. Then commercially they have launched this launched in the market before the grant of the patent for the beta crystalline form of the imetimid mesylate. Now Novartis had sent a legal notice to the Natco Pharma in the UK to stop the selling of the generic version of this imetimid mesylate. And Novartis patent application in the US for the beta crystalline form universal was rejected by the US examiner also. So they have also filed this same patent in the US. So in the US also they have rejected this patent. Novartis says there also they have filed the appeal. So appeal the examiner decision in the board of the appeal, patent appeals and the inferences. So in the US appellate board, they have applied for the appeal for the rejection of this patent. And in its decision, the board had observed that the specification of the main patent, means the parent patent, teaches any person skilled in art how to use the imetimid and the pharmaceutical acceptable salts, because they have write down the salt over there. So based on that, they have given observed that the board is observed that the preparation of the salt is already there. That is given the clue to the person skilled in art person. Then Novartis had not filed for the separate patent for the imetimid mesylate. Two articles are published in the Cancer Research and Nature Medicine in the 1996, means before the filing of the patent, because they have filed the patent in India in the 1998. So authorized by the main inventor of the main patent, then had detailed the discussion about the anti-tumor property of the imetimid and its methasulfonate as salt, means that is the same salt, mesylate salt. So in that 1996, they have given the properties of the imetimid as well as this salt. So based on the above facts, which are already known by the way of the FDA documents and by the way of the any other articles, and for that also they have not applied for the particular patent. So based on that facts, Supreme Court had this parent patent disclose the imetimid mesylate as well as its the pharmacological properties. Because in the 1996 paper, they have given the properties of the imetimid as well as the imetimid mesylate. Thus, the Novartis claim of its invention involving the two inventions failed, and it consists of the only one invention, and that is the process. for the making of the imitated masylates, which is the making imitated masylate suitable for the oral administration had resulted into the beta crystalline form of the imitated masylate, and this finding of the Supreme Court was also essential as the precursor to determine the known substance that beta crystalline form of the imitated masylate should be compared with for the establishing the enhanced efficacy under the section 3D. So these findings, which are taken out by the Supreme Court, due to this, the things is already known into 1996, and how they have interpreted the language of the parent patent. So based on that, that findings will be help out in the future also for the interpretation of the section 3D and the enhancement in the efficacy. Now patentability analysis specifically with respect to the section 3D. So the main arguments of the opponents was that the product was not patentable under the section 3D. So total 5 opponents are there who has filed the pre-grant opposition. In that, they have given the main argument will be related to the section 3D only. So in the section 3D, this is the language they have given, which are as per the our patent law. The section 3D is the mere discovery of new form of a known substance which does not result in the enhancement of non-efficacy of the substance or the mere discovery of any new property, new use of the known substance, or the mere use of the known process, machine, or apparatus, unless such known process result into the new product or employs at least one new reactant. So any new foam will be there, any new salt will be there, any new process will be there, any new apparatus will be there, any new machine will be there for the known product, known process, known apparatus. And if they are not enhancing the efficacy in case of the product, if they are not giving the any new product out of that known new operators, if they are not giving any new product, then they are fall under the section 3D. So in that they have given the explanation which we have already learned into the section 3D. So you can also write down the some of the crux or the summary format of the section 3D in this when you are writing this case. In order to pass the bar of the section 3D, it was required to prove that the product has enhanced efficacy over the known form of the subject matter. So here Novartis has to only prove the one thing only, and that is the enhancement of the efficacy of the new form or the new product over the older product. That only the one thing they can be proved that have to prove by the Novartis. But Novartis has failed to prove that, and will based on that patent will be not granted, and Novartis will be lose the case. Now, what is the non-substance? Now they have given the interpretation by the Supreme Courts or the findings of the Supreme Courts for the non-substance for the efficacy or the therapeutic efficacy. So after the examining the pleading and the expert affidavits of the Supreme Court, what they have observed in the Supreme Court observed that Novartis' argument was that the known substance was imitated was disclosed in the parent patent, from which the beta crystalline form of the imitated masylate was derived, and that this substance immediately preceding beta crystalline form of the imitated masylate was imitated, not the imitated masylate as per the parent patent, did not disclose the imitated masylate. The Supreme Court rejected the argument because it has made the finding that this is disclosing this thing. So in the earlier stage, what the Novartis has argued that in the parent patent only the imitated will be there. There is no clear-cut mentioning of the imitated masylate, but that argument of the Novartis that is not accepted by the Supreme Court, and Supreme Court it told that I have already given the findings how the imitated masylate will be disclosed by the way of the 1996 articles, by the way of the FDA submitted documents, by the way of the interpretation of the language of the parent patent. They have written the pharmaceutical acceptable salt over there. They have written the acid addition salts over there. So based on that, Supreme Court had taken out the findings, and based on that findings, Supreme Court is told that the salt imitated masylate is disclosed into the parent patent. And further, the Supreme Court also rejected this argument in the view of the fact that this was in contrast to the oral and the written submissions of the Novartis before the Supreme Court, wherein Novartis has argued that its invention involves a two-stage removed from the immediate in the free phase, and the substance immediately proceeding the subject product of the immediate masala. So in the written submission and in the oral arguments, they have given the one more argument is there that we have make a process like that. We have removed two steps from that, and from the free immediate masala directly we will get the immediate masala salt. Hence, the Supreme Court concluded that the known substance was immediate masala from which the beta crystalline form of the masala was derived. So, based on that, they have concluded that the known substance that is immediate masala from that beta crystalline form will be separated. So, for the new polymorph, they have concluded that is derived from the old this immediate masala. And efficacy under the section 3D. Now, what is the definition of the efficacy as per the Supreme Court's finding? So, the term efficacy is not defined in the Act because in the Act they have just given that enhancement of efficacy will be there. But the definition of the efficacy is in the Act they have not given. So, the Supreme Court referred the Oxford Dictionary at the time of this judgment and observed that the efficacy means what? So the ability to produce the desired or the intended result. That is as per definition as per the Oxford University, Oxford Dictionary. Now, according to the Supreme Court, observed that the taste of efficacy depends upon the function, utility, or the purpose of the product under the consideration. So, what is the function of that product? What is the circumstances will be there? Based on that, this can be determined or it can be defined. This efficacy, and therefore the Supreme Court had that held that in the case of the medicines whose function is to cure the disease, the taste of efficacy can only be the therapeutic efficacy. So the efficacy means, as per the Oxford Dictionary, is that the ability to produce the desired or intended result. Now, if we are implementing this definition to the different field or different products, so it will be different. And based on the function, based on the utility or the purpose of the product, this can be changed, this definition. So, Supreme Court is now modified this word if we are referring the section 3D for the any medicines or the pharmaceutical product. So, at that time, that efficacy will be referred as a therapeutic efficacy. So, in relation to the enhanced efficacy, the Supreme Court held that the parameters for providing the enhanced therapeutic efficacy, especially in case of the medicines, should receive a narrow and strict interpretation. Because now this is related to the medicine, this is related to the patient's life, human being's life. So, for the interpretation and to prove the therapeutic efficacy, that is a very strict concept. And to prove this thing, that is also strict, and the strict interpretation is required for that. So, to support this interpretation of the Supreme Court, relied on this explanation to the section 3D, which required to derivatives to the differ significantly in the property with regards to the efficacy. Now, in the paper also they have given the different properties. They have also checked on the rate also for the bioavailability. So in that they have write down everywhere about the properties. But the properties and the efficacy both are the different things. Because in the property, if the any particular product, either it's immediate or the immediate masala, if we having the low solubility. So in our body, we know that 70% water will be there. So if the product is not soluble in the water, right? So how it can be solubilized in our body, and how it can be goes to the blood, and how it will be give the effect to that particular part. So for that, the solubility will be increased, and based on that the efficacy will be increased. So the property, the change in the property or description of the property, and to prove the efficacy, this both the things are different, and you cannot correlate or cannot interpret it from the description of the property that based on that property, or as it is the beta crystalline form, so it will give the higher efficacy. So based on property, and no one can judge for the efficacy, specifically therapeutic efficacy. So the Supreme Court held that the new form of the non-substance has to have a significant advantages and the beneficial property over the non-substance in order to pass the bar of the therapeutic efficacy under the section 3D. So if you want to pass the 3D section, then definitely you have to prove that your product or the new product of the non-substance that is the having a very good therapeutic efficacy. Now, however, the Supreme Court pointed out that just because of the word efficacy has to be given in the strict interpretation under Section 3D, that does not in any way means that it bar all the incremental inventions of the chemical and the pharmaceutical substance. Essentially, Section 3D provides the bar that incremental inventions of the chemical and pharmaceutical need to pass the order of the patentability. And for that also the 3D will be there, and with that also three patentability criteria also need to pass. Now, efficacy of the beta crystalline form of the immediate masala. Now, for that, how they have defended for their efficacy for this particular product. So, as discussed above, the Supreme Court held concluded that the known substance has immediate masala and not a free base imetimine. However, all the evidence submitted by the Novartis compared the efficacy of the product with the imetimine. There was no evidence provided by the Novartis which compared the efficacy of the product imetimine with the imetimine acylate. However, the Supreme Court went to examine the expert affidavits submitted by the Novartis, according to which the following properties exhibited by the product demonstrated its enhanced efficacy over the imetimine. So, as such, imetimine have given the details about the properties, details about given the evidence for that the enhancement in the efficacy, but they have not given the comparative study of the raw drug imetimine and the imetimine salad. So, for that, further Supreme Court had checked the affidavits which are provided by the experts of the Novartis. So, in that, what they have checked, Supreme Court checked that the more beneficial they have written down, write down some of the properties as the enhancement in the efficacy. One is the more beneficial flow property. So, as we know that the product is generally in the powder formulation. So, if the flow property will be good, then can be flow into the formation of the tablet and pills, and it can be easily break down into the body and easily give the efficacy. So one, they have given the more beneficial flow property. Second, better thermodynamic stability, means it will be remain stable into the higher temperature and the higher humidity. So that they have given. Third is the lower hygroscopic, means they are not absorbing the water, that particular the salt. And fourth one is the 30% increase in the bioavailability. These 4 points the expert have submitted in the by the way of the affidavit. Now, Supreme Court held that the first three properties, increase in the flow property, increase in the thermodynamic stability, and in lower hygroscopic, these are the properties. They are not the therapeutic efficacy or the efficacy. So the product, this property, first three properties of the product related to the improving the processing and the storage, thus they did not in any way demonstrate the enhancement of the therapeutic efficacy over the immediate masala as required to pass the test of the section 3D. The Supreme Court come to this conclusion even though the affidavit submitted by the Novartis compared to the product over the immediate. Means if they will provide the comparative data of the raw product and the new product, then also Supreme Court will be judged further. Supreme Court after this was left with so now the only fourth criteria will be that 30% increase in the bioavailability. With regards to this, the Supreme Court held this increase in the bioavailability could lead to the enhancement in the efficacy. So now the question is there whether the 30% increase in the bioavailability is equal to the enhancement in the efficacy. So by that way, they have checked that the Supreme Court increase the bioavailability could lead to the enhancement of the efficacy, but it has to be specifically claimed and established by the research data. So in this case, the Supreme Court did not find any research data to this effect of the other than the submission of the council and material. So the things which they have provided, the Novartis has provided by the way of the written submission, in that they have written that the increase in the 30% bioavailability that is equal to the therapeutic efficacy, enhancement of therapeutic efficacy. But in any other research data or any other publications, the Supreme Court will not find these things. Than to indicate that the beta crystalline form of the imidavine masala will produce an enhanced or superior therapeutic efficacy on the molecular basis than that would be achieved with the imitative-free base in the in vivo animals. So, if that rate-related study, if it will be taken for the imetinib also, then it also give the same data. In view of the above findings, Supreme Court held and concluded that the Novartis claim for the product failed both the text of the invention and the patentability under the section 21J, 21JA, and the section 3D. And based on that, this case will be reject. This Novartis will lose this case. Yes. So in this, you have to write down the PDF which I have already sent to you. You can refer those things. In that, they have given the one inventor name as a patent name, which I'm pronouncing the parent patent, right? So in that, they have written the one inventor name that is known as the Jima Maran patent. So you can also remember by the way of the parent patent. So you can also amend this paper in that. There is where you can write down the parent patent. So for the pages, um, the last two pages are not required for the analysis related things. Before that, you can write down the any of the some of the parts. You can the summary of the this case you can take and you can write down over it. So the basically, if we are taking the first one in the 1993 in the quick summary, we will see in the 1993 the parent patent will be filed. This parent patent will be granted in the any other countries, but in the India at that time the product patent will be not allowed. So they have not filed in India. So for the imetinib, they have filed in the US and any other countries, and they are marketing and manufacturing this product. Now in the 1998, they are come up with a new form, that is the imetinib masalat and beta crystalline form of that, and for that new salt and the form they have filed another patent. Now in the another patent, as India has signed the TRIPS agreement in the WTO. So in that, at that time, the product patent will be filing is allowed, but that not be taken for the further process. So that remains that product will be remains as a black box till the 2005. Now in the 2005, that product will be taken for the examination and all. So once it will be taken for the examination, the opposition, pre-grant opposition will be filed. Total five four companies and one association, cancer association, has filed the pre-grant opposition for three grounds: novelty, inventive step, and section 3D. And for these three grounds, they have filed the opposition, and patent office also rejected the patent based on this ground, which are filed by the filed into the pre-grant opposition. Now, once the patent will be rejected, the Novartis has filed the case into the Madras High Court. Now, in the Madras High Court, they have Madras High Court has given the that the patentability criteria for the novelty and the inventive step will be justifiable, but for the section 3D, they have given given the negative sign to the Novartis. So in that sign, now they have given that there no, and at the same time in the 2007, the IPAB will be formed. So in the IPAB, the Novartis also filed an appeal in the IPAB from the Madras High Court, and at the time Madras High Court is telling that because Madras High Court is rejected based on the section 3D, so after that it goes to the IPAB. So at the time, as per the Article 14, Madras High Court told that now this decision is not appealable into the High Court. In the court, they have not mentioned the High Court as per the Article 14 of the Constitution of India. So once in the novel in the IPAB also they have justified that these two criteria will be okay for the for the efficacy or the section 3D. They have failed to comply with that, and that's why based on that will be rejected. Product patent will be rejected, but that process patent will be granted by the IPAB. Now, uh, as the Madras High Court is told no for the further appeal, so the Novartis has filed the special leave petition. Now, in the special leave petition, they are directly filed this appeal in the Supreme Court, and this is the case is very important. And for the interpretation of the Section 3D, this case is very important. And for that, their special leave petition will be accepted by the Supreme Court. Supreme Court will be also check the whole the things, how the patentability criteria will be there. They have checked the invention versus patentability. They have checked the imetinib versus imetinib mesylate, and based on that, they told that these things are known into the parent patent by the way of the FDA documents, by the way of that articles which are published in the 1996. And based on that, they have told that this salt is already known. Now, after that, they also find the about the section 3D. Now, in the section 3D, they have first referred the definition of the what is the section 3D. Then from that, the efficacy will be there. For the efficacy interpretation, they have referred the Oxford Dictionary. Based on that, they have told that for the medicine therapeutic efficacy, we need to check. For the therapeutic efficacy, they have given the some of the interpretation or the findings with that, and they will refer the affidavit which are provided by the Novartis. And in the Novartis, that affidavit, they find out the some property related improvements are there that is not allowed, and for the last, that 30% increment in the bioavailability they have taken as a clause. And in that also they are not the Novartis fail to give the proper data for the comparative study and to prove that the bioavailability and the therapeutic effects both are the same. That is failed by the Novartis, and based on that the Novartis will lose the patent. And with that also in the 2005, before that, the Novartis also applied for the exclusive marketing right, that I forgot to tell. Right? So this is the whole the procedure. You can write down some of the brand names like Livek, the drug name, then in the which year, the some of the year, if you can remember, you can write down those some of the events and the whole the flow from where the 1993 to the 2013, the whole the flow you have to write down by the way of the paragraph or by the way of the table and all. So what happened, the things which exactly the main you have to write down, that is related to therapeutic efficacy, then the invention and the patentability, and how the Supreme Court has take findings for the novelty, for the inventive step, and for the section 3D, that you have to write down. Because when you are reading any of the case, from that what you are learning, or how you can interpreting those things and how you can implement, after interpreting how you can implement it for the further cases, that is the important. So the similar things we have to write down into our examination, the basics about the case, and the how we can implement those things, and how the any other person also implement these findings for the further cases, that we have to write. Clear this? Any question in this? Is it clear?
It's clear. Yes, ma'am.
So this is you can refer this document. It's really good. And the things which they have written, because they have write down the one blog, right? So in the blog or any write up, they have write down the much more thing. But the crux or the summary you can write down, and you can those things you can also write down in the exam also. So do one thing. You all have this document. I will also again share into the WhatsApp. You all will go through it by the tomorrow evening, or the tomorrow night. You will send me the by your hand. You can write down the summary of this case and send back to me. And after checking up all those things, then I will also provide this one summary for that, which you can also write down into your examination. But for this, once you will read, and after that you will write down the summary and the basic about all the whole the case. And almost 3 to 4 pages are enough if they will ask in the 5 or 10 mark. But that 4 pages will cover the A to Z details.
Sure, madam. Definitely.
Is it clear or not, this case?
It's clear, ma'am. Or I have to read it once more. It was really like big one. I'll read
So
it
when
and
you
write.
started reading, at the time also you can write down in book that from this paragraph, this is the important points. For second paragraph, this is important, because this is the legal document, right? We are not referring the actual case or the judgment, but as this is also a legal document, so if you cannot write down, so on the when you are again referring the first page, then you will also confuse what exact the points which you want to take from this. So when you are writing first paragraph, write down the points. Second paragraph, write down the points, and then combine all those points and write down the whole the 3-4 pages short note.
Okay, okay.
Question with respect to this or the whole the patent?